Good evening, dear brothers and sisters. I am once again here with a dictation. You will find the outlines and phrasal outlines of the words as usual at the end of the dictation. Note down the dictation first. Ready, start. Learned Chief Standing Counsel appearing for the state respondents has also referred to the order passed by the respondent number 2 while deciding the appeal, to point out that the appellate order contains a detailed consideration of the case on its merits and the remand having been made with specific directions, the said order can in no manner to held to be a single inverted comma remand simpliciter single inverted comma close and therefore not amenable to the remedy of a revision full stop. It is submitted that the appellate court has recorded a categorical finding that the land is not ancestral in nature and that the parties were in possession according to the boundaries described in their respective sale deeds and would continue in possession in accordance with the same. Full stop. It is further pointed out that the decision in the case of Ram Bhajan within bracket Supra, which is sought to be relied upon on behalf of the petitioner, cannot be held to be good law in the light of a subsequent division bench decision of this court in Dinanath and others versus Deputy Director of Consolidation, wherein while deciding a reference, on the point, it was held that the order of the settlement officer of consolidation, which had finally decided the appeal by setting aside the order of the consolidation officer and remanding the matter to the consolidation officer, was an order finally deciding the appeal and thus could not be termed to be an interlocutory order. Full stop. Learned State Counsel submits that the remand having been made with findings regarding rights of the parties, the order would be appealable as per schedule third and the writ petition would not be maintainable. Full stop. Alternatively, it is submitted that even in case the remedy of appeal is held to be not available, the remedy of revision under section 210 of the code can be availed of. Full stop. The facts of the case regarding which there appears to be no dispute between the contesting parties, is that one half of the undivided share of a plot of land jointly held by two brothers, was purchased by respondent number 6 by means of a registered sale deed executed by one of the co-owners. Full stop. The remaining half of the share was purchased by the petitioner through another sale deed by the other co-sharer. Full stop. The petitioners as well as the contesting respondents got their names mutated in the revenue records as co-sharers of the plot in question. Full stop. Thereafter, the petitioner preferred a suit under section 116 of the Revenue Code for division of the holding in the court of the subdivisional officer. Full stop. The private respondents, though parties in the suit did not file their written statements, and a preliminary decree was made in terms of the order dated 23/1/2019, and thereafter, the suit was finally decreed by an order dated 26/10/2019. Full stop. A restoration application dated 13/12/2019, filed by respondent number 6 seeking recall of the aforestated order, was rejected by the subdivisional magistrate by an order dated 27/12/2021. Full stop. The court, while rejecting the restoration application, also made certain observations on merits. Full stop. The aforestated final order dated 26/10/2019, in terms of which the suit had been decreed, was subjected to an appeal filed by respondent number 6 under section 207 of the Revenue Code. Full stop. An appeal against the said order was also filed by respondent number 5, full stop. The respondent number 6 also preferred an appeal under section 207 of the Revenue Code against the order dated 27/12/2021, in terms of which the restoration application filed by the said respondent had been rejected. Full stop. The three appeals were heard and decided by a common order dated 18/11/2022 passed by the Commissioner, Azamgarh. Full stop.